Sometimes making change to public policy is one of the toughest things that we can do. Because the government believes that in a democracy, no person should or wield power for an indefinite amount of time, the government is proud to affirm the resolution. This House should set a term limit for the U.S. Supreme Court. Resolutional analysis, observation 1, subpoint A. Right to define, we define this as a policy. Should is asking us to enact a policy, which we absolutely will. Subpoint B, the terms. This House will be the U.S. Congress. Should implies that we will do something. Term limits are defined somewhat contextually, but basically term limits mean that a set amount of time in which you can hold a public office. U.S. Supreme Court, again, is defined contextually, but if you're curious, it's that place in Washington, D.C., where the 9 justices sit and hear cases. Subpoint C, the plan. U.S. Congress will pass and then have ratified a constitutional amendment setting a singular 20-year term limit for all new members of the U.S. Supreme Court. Now, this will happen via normal means, although normal means Congress has to pass it, and then in order to amend the Constitution, it must be then ratified. This will be effective immediately. However, current members will be grandfathered in, which means as members leave, new members would then have, as they are brought into the Supreme Court, will fall under this. The D point here is the criteria. The criteria here is net benefits. This is going to be more net beneficial to the U.S. as a country. Background. In 1789, Article 3 of the U.S. Constitution set forth the guidelines for the Supreme Court, one of which is that Supreme Court members are nominated by the President and then ratified by the Senate. Once ratified and confirmed to sit on the bench, they then sit for a lifetime. There are a few exceptions. They could be impeached. No Supreme Court justice has ever been impeached. They can retire, they can resign, but in and of itself, it is a lifetime tenure appointment. Observation 2. You can call this leveling the field. The harms right now the Supreme Court is the only entity with no realistic chance of removal of its members. Congress has re-election to its members. The President has re-election and term limits. States have moved towards term limits in most states. So right now, the Supreme Court is the only entity which sits with a lifetime tenure. Yes, sir?
Isn't that purpose for checks and balances against the other 2 branches?
You can still have checks and balances without it being that way. The inherency here is that all players, President, Congress, must be reelected or somehow face term limits. These limits are set up for state positions. Only Rhode Island, within the Western jurisdiction, has any type of lifetime tenure for any type of justices. So one singular state out of 50 allows this at all. So we can see that the other 49 states and most of our members don't have this. Our solvency here is that the plan changes the quo and sets a systematic term limit for new incoming Supreme Court justices. Now, the impacts here is that, one, it's going to give us new voices and new ideas within the court. It's going to decrease the amount of politics in the appointments of these Supreme Court justices. It's going to help to usher out judges that have some mental depacification. Can't say the word. 1 second there. It's going to lower the loss. It's going to lower stamina issues because justices sit for so long on the bench in a stressful position. It's going to eliminate strategic retirement of justices that plan and choose when they want to retire to help with appointments. It's going to reduce anxiety in confirmation hearings because these aren't going to be so set forth, because we know there will be more confirmation hearings. It's not going to be the golden egg that presidents tend to get when all of a sudden something comes up for them. And it's going to raise the traditional level of justice, of judicial interpretation and judicial importance. Yes, sir.
So you talked about, so you're implying that all these judges don't have the capabilities of having mental stability. What's the warrant for that?
I didn't say they did. So observation 3, you can tagline this that the system is out of date. The system is out of date. The harms right now is currently the makeup of a court often and currently represents some past ideologies, including past ideologies that can stretch back almost 30 years. My inherency here is that we get a court that isn't always necessarily in tune with current times. Now, tenure, pre-Civil War tenure for the Supreme Court sat at about 15 years. Currently, tenure sits at about 26 years. You can see a difference of almost 11 years. Now, you also can figure that when the framers set forth this, there was a different level of life expectancy. People just did not live as long. So developing a system that now seems to have outworn itself, seems to run its course, because we now have a much longer life expectancy in general. The solvency here, once again, is that the plan sets forth a singular term limit of 20 years for new justices coming in. My impacts here are several. I mean, first is it raises, it creates more current interest and current ideology in the court. It allows for a continual set rotation as justices retire and then turns over every 20 years, but not all 20 years at the same time, as justices in the current course will retire, pass away, whatever. I'm in protected time, sir. So on. This is also going to increase new ideologies within the court, because you're going to have new people sitting on the court. You're going to have new ideas on the court. Now, again, this doesn't mean the court becomes a political statement by any means. What it means is that new people bring new ideas. New ideas get festered into conversations. They get festered into when they're having their conversation about how a case should be handled. This also is going to increase access to the court, because now there's going to be more opportunity for more people to potentially be appointed. You may see a movement to appoint some younger justices, because they don't have the ability to now sit on the court for 35, 40, potentially 50 years as someone who was 30 or 35 was appointed. You also will see an increase of these judges returning to public service and now working in other fields of public service and going forth. So once again, we are proud to affirm that this House should set term limits for the U.S. Supreme Court.
Off-time roadmap, I'm going to have 4 off-case positions, and then I'll go case. We think that the institution that is the Supreme Court of the United States was put in place for a really good reason, and that life appointments are really important. But we think that even if there is an issue, that we have a better counter plan that's going to solve better than them, that will avoid our disadvantages. So first, let's get to our disadvantage 1, entitled Less Justice. So the A point is, right now with lifetime appointments, there is no need for justices to try to look for jobs after their appointments or to try to act in a way that could get them employment afterward. So their job simply is just to make a decision based on whether or not something is constitutional, regardless of public opinion. The whole reason lifetime appointments were put in place was so that the justices could make decisions outside of public opinion, and that they wouldn't have to feel like public opinion matters. So the B point is the link. Their plan removes the life appointment, causing them now to act in ways that are going to make them look for jobs after, or that are going to make them look good to employers after. So the C point, let's look at some of these internal links. They're going to make decisions based on their own political interests and their own political careers. So they're not going to want to do something that the public largely doesn't like, because they know that could hurt their employment. So for example, the Hobby Lobby decision about contraceptives for women. If you're a Supreme Court justice that is good at business law and you're like, well, I'm going to have to get a job after my term is up, then you're not going to want to rule against Hobby Lobby and say, because then Hobby Lobby has all that influence in the private sector. So it's going to make it a lot more difficult to fight back against the private sector. So let's get to impacts. 1, private sector has more influence and it's more difficult to fight back. And I was talking about that with the Hobby Lobby example. The second impact is that every decision is now going to be made with the notion that this could hurt that justice's career. That impact is basically decisions are not made constitutionally, but are made in the interest of the judges. ultimately, the larger impact is less justice. When they're not doing their job, which is something constitutional or not, and instead they're like, I have to look out for my own self-interest, there's going to be less justice, and we're not going to see some of the historic increases in civil rights and other rights that we've seen throughout our history. Now let's move to our second disadvantage. You can title this disadvantage 2 of experience. So the A point is that right now, Supreme Court justices have a difficult job that not everybody is cut out for. For example, Ronald Reagan had 2 of his Supreme Court justice nominees rejected because the Congress didn't think that they were up to the task. So proving that this is not a job just for anybody. But further, the lifetime appointment right now allows justices to stay as a justice through transformative periods in U.S. history. What this does is it allows justices to have context of what happened before and what's happening currently in order to try to formulate the most constitutional and really most just ruling. So, for example, let's look at some really historic Supreme Court justices and how it would be bad if their terms were limited. First, let's look at Supreme Court Justice currently, Sonia Sotomayor, the first female Latina Supreme Court Justice. If her term limit was limited, whereas all the white guys who got to serve before her got to serve unlimited terms, that is just blatantly unfair. Secondly, let's look at Thurgood Marshall, the first African American justice on the Supreme Court, who actually presided over a lot of social justice cases, and if his term limit was limited, whereas all the white guys before him get to have unlimited terms, that's blatantly unfair. Let's look at Sandra Day O'Connor, the first female justice ever on the Supreme Court. If her term limit was limited, but all the men who get to go before her just have unlimited term limits, that's blatantly unfair. So the B point is that their plan just basically takes away this experience, this ability to sit over transformative periods in the U.S. to allow for context. Internal links, you have more inexperienced justices, and it's harder to find qualified justices. If Reagan had 2 of his appointments rejected, that means that Congress, because justices they're gonna be experiencing more turnover, it's gonna be harder for Congress to turn away justices because they're gonna need justices, and if they turn them all away, then you won't have a functioning Supreme Court. Finally, justices are going to be unable to realize their potential, like Thurgood Marshall and Sandra Day O'Connor, who after 20, even 25 years on the court, end up making groundbreaking decisions that are still the case today. With their plan, that's not able to happen. So the impact is you have a slower, less experienced, but ultimately less just government that doesn't make decisions contextually. Now, counterplan is that judges... there will be a mandatory retirement at age 80, and we're doing that. So first, the competition is you can't have term limits, but then also a retirement age at 80 because they would literally be in a direct competition with each other. Because if someone's already served a certain amount of years. But the second part of this counterplan is no term limits, but the retirement is at age 80. So that's why it's competitive, because our counterplan includes no term limits. We get all the solvency that they do, which is our net benefit. Plus, it doesn't bite our DAs, right? Because when you allow a justice to be on at age 80, they're allowed to serve for 30, 40, depending on what age they were put in at. And all of the warrants that I've brought up, all of them made historic decisions before they turned 80 years old. So our counterplan doesn't affect any of them. Yeah, what's up?
Have any of the justices you brought up, were they ever appointed after the age of 60?
I didn't look in my research, but I don't think so. So now let's get to their advantage called leveling the field. Their A point they bring up is they say that the Supreme Court is the only entity that can't remove its members. First of all, that's just false. So the Supreme Court justices can be impeached just as a president can. It hasn't happened, though. But they can remove their members. It's not like the inherency is that there's a law that says under no circumstances can they be removed. They can if they are shown to be inadequate or anything else. But secondly, the reason that that's in place is for checks and balances. Like Lasai brought up in the point of information, that it's really important that we have checks and balances so that the Supreme Court can serve as a check to the executive branch, so that the executive branch can't just be like, oh, we don't like the Supreme Court, therefore we're going to impose term limits and then get to pick who we replace you with. No, it makes it so that the judicial branch is not beholden to the Congress or the executive branch. Now let's drop down to their impacts. First, they say their plan is going to decrease politics. Turn that, it's going to increase politics as more justices are going to be like trying to make decisions that are like politically based, so that it helps their careers afterwards. So that's a turn. Second, they say it's going to increase voices. I'm gonna turn that and say it's going to decrease them, because even though there's going to be more justices, they're not going to want to say how they really feel, because that's going to hurt them in the long run. So it's going to decrease the amount of at least good voices. They say it's going to eliminate stamina issues. I'm going to impact turn this, but basically say that stamina issues, as they frame them, is not the case. Like cross-apply are disadvantaged about like experience, where stamina is important to help them stay on the court over transformative periods in history. They don't get tired or fatigued. And so turn all of their impacts. They have no warrants either for how any of their impacts occur. So that's the end of my time, and I'd like to oppose and vote opposition.
Okay, for just a quick off-time roadmap, I'm going to go off case and then on. So starting, thanks everyone for being here, but let's just get right into this. Starting with their DA1 of less justice, their A point here is there's no need for justices right now to look for jobs after, and I will say this whole DA is non-unique, because right now, even if you impose 20-year term limits, they have to be there for 20 years. They're going to come out older with full retirement benefits if they've served 15 or more years. So that means they don't have to look for jobs afterwards. How many 70-year-old people are going to go out there and look for jobs? So first of all, it's non-unique because these justices don't even look for jobs in the first place. My second is public opinion still won't matter. Because they can always get jobs as like think tanks or even at universities and teaching positions. Condoleezza Rice teaches at Stanford, and she was part of one of the most political and like politically criticized at the time administrations in history. So that's so they still can find jobs fairly easily regardless of their politics. Yes, Joe?
So you're saying that they are going to have to find jobs afterward?
I'm going to say,
or that they'll be able to, or that like
they'll be able to. Most of them won't, because anybody who's qualified to sit on the Supreme Court is probably going to be older, more experienced, so 50 plus. So that means they're going to be coming out of this court at 70, 80. So they won't need jobs, first of all. But if they somehow do need jobs, it's really easy for high-level constitutional lawyers to find teaching jobs or think tank jobs. We see how many congressmen get right out of Congress and go work for the private sector, meaning that it doesn't matter what their politics are, they will still find jobs. So none of these concerns so they won't have to like mitigate their decisions to hope for job future. So just they have no access to any of their impacts. The private sector doesn't get more power because they'll just go to whatever group already supports their views, and it won't hurt justices' career because most of them won't even have careers. And then secondly, they'll be able to go to like teaching institutions, and then it won't decrease justice because it's not going to actually affect anything. And then it's also not going to decrease civil rights because it's going to actually bring more voices, more people's opinion, like younger, anybody, if there's more people who have more voices, that's going to have younger people who are more open to like new civil rights. So then let's get on to their GA2 of experience. That SCOTUS is a hard job. First of all, I think 20 years is plenty of time to go over transformative changes. Like yes, Joe?
Why do you think 20 years is enough time?
Because big movements don't usually take a full like 20 years if they're in court. But then, second of all, 26 years is like the average. Most people serve for, before the Civil War, 11 years was enough. So 20 years is plenty of time, so their A point doesn't really stand. But then let's get on to their B point of Sonia Sotomayor and how it would be unfair because the white justices that came before him had unlimited term. It wouldn't be unfair to her unless she was the only one to get term limits, because everyone in the future will get term limits. It's inherently fair. It would be unfair to give people like this special treatment. And they wouldn't even approve of it, because as long as you're giving everybody that 20-year term, it's still just as fair, because we're trying to increase democracy, we're trying to increase ideas, and we'll probably have room for more minority judges who will come in, because you can have younger or newer people taking these jobs and not people who are going to sit there for potentially 30, 40, 50 years. So our plan does not take away from experience, because 20 years is plenty of experience. Plus, they've been sitting on lower courts or been lawyers for a long time before they even get to the Supreme Court. So none of these things really matter. If you don't think 20 years is long enough to get good at your job, I don't know what is. And now to the counter plan of mandatory retirement. I first have to say this is just simply ageist. You're preventing people over 80 from having a voice in politics, which is inherently unfair. It's inherently ageist. So if anything, if you're still young and vibrant, going on 80, you should be able to have a voice or still have hopes for, being a Supreme Court justice. Just because it took you, just because you were 65 when you were appointed to the Supreme Court, doesn't mean you should have to leave 5 years before somebody who was appointed when they were 55. So I don't think age should really have anything to do with Supreme Court nominations. This is just really discriminatory to the elderly or people of age. So, Judge, I don't think anyone would even support this, because you're taking away voices of everyone and you're limiting diversity with that plan. So the plan really limits the diversity of the court as ours increases diversity. So now let's get on to our on case, which is leveling the field. So right now, one of their objections to our A point is that that Supreme Court justices can remove members, but we did say that you can remove them. It just never happens. It never has happened. The country has been around for over 200 years. The court has been around for over 200 years, and still it's never happened in the history of America. So it's not like a thing you should even be considering. People in the Supreme Court still stay pretty much until they want to leave or until, they pass away. Yes, Lasai?
Your only harm that you guys are trying to solve for is that Supreme Court justices can have no chance of removal, and they can be removable, but the fact that they've never been removed, isn't that saying that's a good thing because they've never done anything justified to be removed?
No, it's like, it's almost an undue burden of you're just going to keep people there longer for tradition and not for, because they're actually having new ideas. So they are staying extra long, but so it's hard to get them out is what we're saying. It's very hard to make that change. And no Supreme Court is going to want to break that precedent. So then they said this is for checks and balances. We still have checks and balances. In fact, we have even more checks and balances on the Supreme Court itself, because you can't stay there for life, because you can't sit there for, potentially 30 to 40 years. There are more checks and balances. That means you're limiting the power that one president has over the future of an entire country. If a radical president comes in on a wave of support and suddenly is able to nominate a Supreme Court justice, without term limits, that justice could stay for potentially 3 or 4 decades, which means they would have intergenerational impacts to this. Then they tried to turn that it would be politically biased and no voices, but like you saw with their criticism, there's no political motivation to reduce your sentencing. And then for observation 3, I just want to say they dropped that entirely, so you can just flow that all across, Judge. Thank you.
Okay, for a roadmap, I'm going to go off case in order and then on case in order. Okay, I'd like to thank everyone for being here today. I'm just going to get right into this debate. For DA1 of less justice, their arguments responded was that it's non-unique because 20 years is enough, and at the time over the 20 years it said that they're going to be old and benefit, that they're not going to have to look for jobs after this. However, in the PMC says that their plan pushes for more younger Supreme Court justices, which when their plan pushes for younger Supreme Court justices, that bites right into our DA, because now that we're going to see their plan creates younger justice of the Supreme Court, means that when they come out of the 20 years, they're still going to want to have their careers after their 20 years. Let's say that currently the status quo from the Supreme Court justice when they're elected is 51 years. So if their plan is going to push for younger than that, let's say the plan pushes to them, many people being elected at the age of 40, they come out at the age of 60, or some even come out at the age of the high 50s, in which we see that how they mentioned that life expectancy is going up, so that means the retirement age, the age that people retire, is also going up as well. So we see their DA still stands with people being influenced by private sector, being influenced by politics, and based on public opinions and how they don't want that to affect their jobs. Yes.
Can you discuss how this would change the concept of senior status within the Supreme Court?
Well, the concept of senior status, I'm going to skip that because I'm not really sure what you mean by senior status from that word. Okay, when we talk about the private sector's influence, he admits that this is a problem because he says, well, they could just go to private sectors that support them. And that just limits their abilities to get a job and limits their abilities of who they could work for and get support for. So he's agreeing that we do have impacts by saying that they could just choose other options, and that's just agreeing that we do have impacts and saying that our DA is not unique at all. So when we go into the DA of 2 about experience, we talk about how that 20 years, that how we brought up a story about, my partner brought up a story about a specific Supreme Court justice, how that he made groundbreaking decisions after 20 years of experience. And this was something that wouldn't be able to happen with their plan because he would have been forced to end his career after 20 years. Yes, question.
Can you specifically talk about what those groundbreaking decisions were?
Desegregation.
It was desegregation, in which that is something that he helped for after 20 years of tenure. And I'm not going to take back-to-back questions. I'm going to go a little bit through this a little bit. And so they say that 20 years is plenty of time, or I'm just going to argue that 20 years is not plenty of time for a Supreme Court justice to fully develop and go through the periods of changes and go through the different periods of public opinions and different movements. And if we were to have new justices every 20 years, that's just going to destabilize the stability of our Supreme Court justice. And just like one of the sayings that if it ain't broke, don't fix it. And the current system has been working for not setting term limits, so we shouldn't change that tradition of 200 years with their plan. And so when we go into our counter plan, they say that they're trying to say that our counter plan is only bad for the reason that it prevents people over the age of 80 from having a voice in politics. And they said that age should have nothing to do with it, but their whole case construction on the PMC had a huge part about old age when they talk about how their plan promotes striving for younger Supreme Court justice, and they talk about in their direct impacts of their 81, they say about how it's going to decrease stamina, and how it's going to decrease the mental, something but mental. What that both implies that old people shouldn't be in the Supreme Court justice. So now they're kind of going back and forth on what they truly value with our Supreme Court justice, because they talk about the stamina and mental capabilities of older justices and how their plan promotes pushing for younger justice. So they truly agree with our counter plan that at a certain age that people shouldn't serve in the Supreme Court justice, and they're just going back and forth. They don't have one coherent voice coming from our opponents. And our counter plan doesn't invite into our DAs of experience, because people can have over 30 years of experience and retire at the age of 30. People that are put at the office can have, at the age of 80, will not need to look for jobs, so they won't be influenced from any type of political opinions or politics. And so now when we go into on case, when their advantage ones, their only harms is that Supreme Court is the only entity that has life tenure and that there's no chance of renewal. And so when you have impacts, your impacts have to solve for the harms. And when they bring up like 6 different impacts, that none of these really come out of that one harm statement. So they don't really get the impacts of like the mental capability, stamina capability, strategic, renewal, or the politics. They do the only ones they can strive for is the impacts of the new voices and ideas and the traditional level. But however, we mentioned that they provided no warrants about how their plan is going to promote new voices, because what's the significant difference in magnitude they did not provide of having Supreme Court justice serve for 20 years, in which that's not going to promote that much magnitude of new voices and new ideas, because it's every 20 years. Also, when we talk about the checks and balances, what we meant was that 1 out of 3 branches need to not be influenced by public opinions and politics, and that's why the framers intended for life tenures, in which that's the checks and balances that we brought up, and that's what the framers wanted. They wanted, because the other 2 branches have term limits, and that means that they are influenced by public opinions and politics, in which the judicial branch is not influenced because they have life tenures. Yes.
Initially, presidents didn't have term limits because that's how the framers set it up, but now they do. So why do you think the framers have a different opinion on Supreme Court justices but not presidents?
Because the Supreme Court justice is a judicial branch, and they want that one branch to have no public opinion or influence. And they need at least one branch to stay that way. And if we give all 3 branches the ability to have influence from public opinion, then they're all going to be voting based on public opinion, and none of one's going to uphold the Constitution, in which we need someone to hold up the Constitution. Your plan goes against the Constitution and goes more for public opinion and for what's best for personal interest and personal gain and motivation based on the Constitution. And so when we go into their 82 out of date, they talk about the harms of that the current makeup represents, and that we get current times and different levels of life expectancy. Their impacts, you drop down to their impacts and say it creates more current interest in court, new ideology, and they don't bring up any type of examples of what current interest is going to be changed or what type of new ideology is going to be changed and how this has a strong magnitude, because they don't provide any examples or evidence of what is actually going to change. So I'm going to say that their impacts have no probability, because 20 years is not enough to 20 years term limit is not enough to create that much current interest in the court or create that much new ideology, in which they basically get no solvency for all their impacts on 82, because 20 years is not enough to create any type of magnitude.
And only 4.
I'm going to just get right into voters, because there are 6 of them. First, their plan puts more politics into the Supreme Court, which is where politics should not be. They talk about their plan means justices are going to be younger, meaning that after 20 years, they're more likely to need to get jobs after, like Lasai said. And then when they say they can go to think tanks or universities, those are largely political institutions. And then also said, like Lasai said, when you're saying that, well, they can just go to like partisan employment or like whoever agrees with them politically, that just proves that we have impacts that are going to happen. And so while that might be okay for the Supreme Court judge itself, it's terrible for the Supreme Court and the country, because then that judge is making decisions based on their personal future. Second voter is less justice. So their plan gets us less justice when judges are making decisions based on their own personal futures and politics is involved. Third voter, like Lasai said, if it ain't broke, don't fix it. So the government team has the burden of coming up with a harm scenario, a problem that needs to be solved. They just say their only harm scenario is that the Supreme Court people like they can't ever be off of it because of the lifetime appointment. They don't say why that's bad. We tell you a lot of reasons why that is good. Because they have no harm scenario, you're going to be voting for opposition based on presumption that the status quo is good. It is solving. We have civil rights. Granted, we could use more, but quo is solving, so you're going to be voting off on presumption. Plus the fact that we have disadvantages to their case, like justice and politics, that bring up real risk in their case. Fourth voter, experience. And what we mean by this is not like, oh, well, you're not good at your job unless you do it for 20 years. What we mean is that justices that serve a lifetime appointment serve on the Supreme Court over transformative periods in the United States history. And so this is really important because when they make the argument that Lasai hit as well, that social issues don't take longer than 20 years. So 20 years is enough time. I think you can see that just this argument in itself is showing that maybe they're not understanding the role that justice plays and how the role that context plays throughout our country's history. Like, we'll give you some examples right now of social issues that take longer than 20 years. Women's rights took longer than 20 years and still isn't finished. Civil rights took longer than 20 years and probably still isn't finished. LGBTQ rights took longer than 20 years and isn't finished. The list goes on. Basically, like any social issue, even political issues take longer than 20 years, which is why lifetime appointments are so important, so that they can see that issue from its onset to hopefully them ending it because they're making a just decision. Fifth voter. You're going to be voting for opposition because you're going to prefer our turns to their advantages with warrants. Okay, so like when we talk about like specific justices where like if they weren't able to serve for the lifetime appointment, certain big historic changes wouldn't happen. But the second part of that is that they bring us no warrants at all. They haven't given us one case, not one justice, not one expert, not one poll, not one article that supports what they're saying, and we give you a lot of reasons why that's risky and how like current like cases in the past and justices in the past, it would be hurtful too. Whereas in our case, we brought up 3 Supreme Court justices, multiple cases, Hobby Lobby, segregation, and then Lasai brings up warrants on like the average age of justices being confirmed. So we bring all this information when really the burden of proof should be on the government side. We're the ones bringing it. That's why you're going to be voting for opposition. Finally, even if you think if you do think that it's a harm that judges can't be removed, then you're going to prefer counterplan. 1, it's competitive, and 2, like their case even had things about like how them being really old can be bad. But secondly, like that's not the hugest part of our case. You're going to be preferring our 5 main voters. Thanks.
All right, once again, thank you for everyone for being here. We have a lot to get to, so here we go. First of all, when you look at plan versus counterplan, you can just kick counterplan. And I quote from the leader of opposition, lifetime appointments are so important. Lifetime appointments are so necessary. Stick to lifetime appointments. If they feel all this, why do they offer you a counterplan? If they feel SQO is correct, why offer a counterplan? They offer a counterplan just to make us get up here and talk about it? Did they get up here? I mean, I point out that he ignored my question for about 2.5 minutes, so maybe he just doesn't want to talk about that stuff. But again, why offer a counterplan if you repetitively say in your first 4 voters, lifetime appointments are so important? So I think you could just kick any counterplan, anything they try to associate with it, anything that they try to link to it. Okay, on to their voter number 1, that their plan, I'm not sure if it's their plan increases politics or the SQO would increase politics. My answer is this, that the Supreme Court in and of itself is not a political position. So we didn't change anything about how they're put into office. No one's voting for them other than Congress. So the SQO is actually the same as the process. So politics neither go up nor go down. What you do see is when we get into my voters, how ideas go up. Voter number 2, they say it decreases justice because they're worried about their personal future and stuff like that. They weren't even aware of what senior status is. Senior status basically says that after 15 years of appointment on the court, you're eligible for full benefits of the court for a lifetime. So therefore, A, it's unnecessary to go find a job. B, if anyone thinks that a retiree or someone that gets termed out for the Supreme Court justice can't go find a job, I mean, they're really being naive. So you could just kick that. Voter number 3, if it's not broke, don't fix it. Well, that's really unfortunate because when you get into debate worlds, you look at things and you fix them, even if you can't do it in real life. If you don't think that the movement towards term limits, if you don't think term limits is good, then that's unfortunate. Voter number 4, they talk about experience and transitional periods. I think this refers to like making for a lifetime and stuff like that. 20 years is still a long time. I would say that when you talk about women's rights, when you talk about LGBT rights, when you talk about any type of rights, okay, they last more than 20 years, less than 20 years. They're an ongoing process. So Supreme Court members, even at their point, at some point, if you have the plan, would be eliminated at age 80. So again, it's non-unique. Let's get into my voters because this is what really matters. Voter number 1 is observation number 3. And again, don't look at your flow because the member of op just tries to get up here and start talking about it, but it was completely dropped in the leader of op. They have no access to it. So you can vote right there. You can vote strictly on observation 3 because it was completely dropped. And because you can vote on that, that means you can vote on all the impacts that observation 3 brought, that we increase current interest and ideology, that we allow for more we will allow for continual rotation of these justices, that it actually decreases benefits. We allow for new ideologies. We allow more people that will have access to the court, and that we get judges to return to public service. Flow it all the way across because it was dropped. Voter number 2 is plan versus counter plan. They're arguing against their own counter plan into things, so you've got to prefer plan. We've given you plenty of reasons to prefer the plan. Voter number 3, and let's call it stamina, let's call it ideology, let's just call it ageist. Because their plan not only bites into being ageist and wasn't really responded to at all, but again, when they talk about stamina, we never said that stamina was an issue for the older judges. We said stamina for sitting on the court for a long time creates issues. They just make the assumption that we're talking about older people or elderly people. So grandma, grandpa, if you're out there, I'm sorry they feel that way, but everyone can have stamina issues. Everyone can have health issues. It's not related to only older people. Now, the voter number 4 is we'll call it experience like they do. They say 20 years is not enough to change voices and stuff like that. I point out right now that if we had this rule in place previously, 5 justices that sit on the Supreme Court right now would not be sitting there. So 20 years obviously would have changed the makeup of the Supreme Court, which would have changed outcomes. And voter number 5, I'll talk about framers' impact. They didn't really respond, or I don't think they responded well, they changed it for presidents. Why don't they change it for Supreme Courts? Oh, well, they just wanted the checks and balance. It wasn't a solid answer. We do make changes. So, Judge, what world do you want to live in where we give lifetime tenure regardless for no reason? I don't think that's the world we want to live in. I've given you plenty of reasons to vote for our plan. Our plan doesn't disrupt the flow, but it does change it. So again, most importantly, you're going to be voting today because A, the plan is completely preferred over the counter plan because they argued against their own counter plan during the voters, and B, your voter number 1, you need to look no further than observation 3 completely dropped and flowed across. You are allowed to vote on a dropped issue in and of itself. That's why you'll be voting for us. So once again, I am proud to affirm. Thank you.